Hi guys, my name is Mutsa Tomana. I'm a final year student studying international relations with the Africa University. During this semester, I'm doing a course in government politics and global perspectives, and one of my requirements is to do this video assignment. In this video assignment, we're going to be looking at, or rather examining, the racial biases and discriminations that exist within the International Criminal Court. Stay tuned for more. We're going to be examining the racial biases of the International Criminal Court against Africa. Our study questions and objectives are as follows. What are the political implications of the work of the ICC in Africa? What impact, if any, has it had on conflict resolution, peace building, the rule of law, and the struggle to end impunity? Is the court's pursuit of retributive and punitive justice an obstacle to peacemaking and reconciliation? Should the ICC adopt a more nuanced approach? Could the ICC's intervention be worsening already deadly conflicts? And lastly, has the ICC suffered politically because of charges by some that it has selectively targeted poor countries in Africa? At this point, we're going to look at the International Court of Justice and the Rome Statute. The ICJ was established under the United Nations in 1945 after the Second World War. It created the international legal framework for states, creating the platform to settle disputes between states in a similar manner and to provide advisory opinions in relation to legal issues. According to Article 93 of the UN Charter, all member states are party to the court statute, giving it the largest jurisdiction in the world. However, because the ICJ plays major attention to state affairs, there was need to narrow the scope to individuals, leading to the formation of the ICC. The Rome Statute was established in 1998, creating the International Criminal Court, which was enacted and began working in 2002. Moving on, we're going to look at the emergence of the ICC. The ICC was a necessity that provided a platform to prosecute and punish individuals or collectives found guilty of war crimes, acts of terrorism, and human rights violations, such as the Holocaust and the Rwandan genocide. Key to note that these large-scale atrocities are usually political or ideological in nature, meaning the perpetrators are often operate from political platforms and use political reasoning to justify their crimes. Joining the ICC required states to pledge their cooperation with the court in terms of investigation, arrests, and transfers. It's important to understand that before this was established, states had a certain level of sovereignty, which allowed them to protect their citizens, whether they're criminals or innocent. So with the ICC, that meant that to a certain degree, this meant that states surrendered the right that they had to protect their citizens from being put out in international platforms. It's important to note that after the establishment of the ICC, the USA Congress passed the American Service Members Protection, also known as the Hague Invasion Act, which gave the US President the power to use all means appropriate and necessary to bring about the release of any US or allied personnel being detained or imprisoned on behalf or at the request of the ICC. Looking at this, this presented a weakness to the ICC because after the stance or the demands of the ICC, America went on to protect its nationality, to protect its sovereignty by establishing the Hague Act, the Hague Invasion Act. For the first decade of the ICC, Africa was the only continent from which individuals received ICC rulings, but it's also important to note that Africa also referred a lot of these cases to the ICC. Moving on, we want to understand the usefulness of the ICC. Questions or threats to state sovereignty. As we established and pointed out earlier on, by establishing the ICC, nations surrendered a certain level of their sovereignty, allowing ICC jurisdiction within the parameters of their states. The ICC has often been described as a neo-colonial tool used by the West to push their agenda and play their hand in African political landscapes, appointing itself as a judge and a jury. Basically, the ICC has given itself the power to. Past years, Africa has indeed shown great faith in the governing body, referring several cases to the ICC. But of late, the question is why Africa is the only continent constantly having their cases tried, and yet all other criminals are not being brought to book. So at this juncture, we see that Africa has taken a different approach to the ICC. For the past decades, we've witnessed Africa sending cases to the ICC because of its faith in the body to try their cases of criminals who need to be put to book. But after looking at some of the other cases that have been interrogated by the ICC, there's a bias of things just being tried on the African continent and other continents being left to do as they please. At this juncture, we're going to unpack the other variable of our topic, which is racism. Racism can be defined as the systematic prejudice, discrimination, and/or antagonism by an individual, community, or institution against a person or people on the basis of their membership in particular racial or ethnic group. It can also be termed as a belief that that race is a fundamental determinant of human traits, capacity, and capabilities, and that racial differences produce an inherent superiority and inferiority. On the scope of Africa and the West, we know that the West has always deemed itself much more superior to the African continent. And with this in mind, is the ICC implying that Africans are incompetent and incapable of solving their own issues, of solving their own cases, of bringing their own criminals to book? Moving on, we're going to look at racism and the conflict of it within the ICC. There's been growing sentiment of racism in the institutes like the ICC towards Africa. In 2022, the ICC had 14 active investigations, 85% originating from Africa or the Middle East. This amplifies the existence of selective and preferential prosecution within the court, which has led to increased disgruntlement from African countries towards the court. Improper balance and distribution of power within the Security Council, which has 5 permanent members being the USA, UK, France, China, and Russia, have the power to refer cases to the ICC. Using a simpler example of what I'm saying here is, take for example a situation where in a class you have a class monitor that has been appointed to record noisemakers in the absence of a supervisor or a teacher. This class monitor may decide to omit their peers, omit themselves, even if they had been making noise or doing what they're not supposed to be doing, and instead pay more attention and focus on those who are actually making noise that don't concern them, that are not their peers. This can be attributed to the Security Council, and what it actually refers back to the ICC to try and investigate. Is there a chance that USA would refer a case that brings itself into question and leave other states that are smaller with other issues going on? Food for thought. The UN Security Council ruling states naturally have allies and enemies. As a result, the Council tends to be selective in cases it refers to the ICC. For example, the ICC has recommended investigations in Libya and Darfur, and yet it managed to sideline Israel and Syria. And we know that from the permanent members, they have vested interest in these areas that have been ignored, and yet they themselves are perpetrators of some serious war crimes and human rights violations. Moving on to the political dilemma of the ICC and Africa. Ugandan President Museveni is seen to be a hypocritical figure. Why? Earlier on, Museveni had issues with Joseph Kony, a leader of a rebel group in Uganda. At this point, he referred or sought the help and assistance of the ICC to come and intervene with these issues, which they did. But we see how Museveni used the ICC when he needed them to deal with a problem that he couldn't deal with by himself. But now we see that he is one of the key figures in Africa who are calling for all other African nations to withdraw membership from the ICC. Why is that? It has come to a point in time where we can see that even African leaders who want to call the ICC a racist body can at times use the ICC as a shield to deal with their own problems, but when it comes to times whereby they can be tried or they try to protect themselves from the ICC, they take such moves as trying to withdraw themselves from the REM statute. Moving on to our second dilemma, we've got the former president of Sudan, President Omar al-Bashir. It's important to note that Sudan is not party or a part of the Rome Statute. As a result, it should not be governed by what the ICC states or what the ICC expects from states that fall under it. In 2009, however, the ICC issued an arrest warrant on al-Bashir. At this point, we saw this stance by the ICC creating diplomatic tension within the continent. Why is that? Shortly after that, we had the South African president preparing for his inauguration, and as usual, presidents invite other presidents to attend such events. But at this point, the South African president made it clear that if al-Bashir entered South Africa, he would be left with no choice but to arrest him and hand him over to the ICC. However, in 2011, the Malawian president took a different stance to this, acknowledging and respecting the fact that Sudan was not part of the Rome State, which means that the laws that govern the ICC should not be applying to Sudan at that time. As a result, he said that al-Bashir was free to come to his country and he would not take any stance because he respected the sovereignty of Sudan and its stance in not being part of the Rome State. Now, if Africa does not want to take part in the Rome Statute, it should have some body in position to ensure that all atrocities that happen within the continent, or war crimes, or terrorism, or human rights violations should still be brought to book effectively, regardless of position, state, or sovereignty, because these things cannot go unpunished. Whether you are a president, whether you are a rebel leader, whether you're an ordinary civilian, these things should not be done without any repercussions. Thank you. At this stage of the presentation, we're going to take some time to hear what other people think about what we've been deliberating on. Hi.
Hi.
I'm just going to ask you two questions.
Sure thing.
First being, do you think it's too ambitious for African countries to be pulling out of ICC?
I think it is, because the ICC exists for a reason, right? And if you leave the ICC, I'm sure their mandate is to prevent war crimes, or to hold people accountable for certain things. If you leave that system, I think it creates an avenue for you to just do those very things with no one to hold you accountable. And it's ambitious, but I think it ultimately is probably a bad move, and is probably not the way to go. Maybe trying to find the problems and then fix them. I don't know how, but I think leaving, it's just like saying, because some people are wrongfully convicted by law here in Zimbabwe, then you disband the Supreme Court, for instance. I think they do more good than they do harm.
My next question to you was going to be, what's the way forward for African countries in dealing with human rights violations, war crimes, and their perpetrators, and terrorism? Like you said, you still have the question of people still committing these crimes and they need to be brought to book. Say the African countries did pull out of the ICC, what do you think would be their best way forward to still deal with the terror that's going on in Africa, the war crimes, the human rights violations?
I think these human rights violations, I think particularly in Africa, they stem from somewhere, and you find that more often than not, it's the government of the day that is involved in these atrocities. And unfortunately, because of state sovereignty and immunity of a president, for example, you can't bring those people to book. So I think even if you are to remove the ICC and replace it with an African tribunal or something, it'll be plagued by those same problems where it's the governments of the day that are committing some of these crimes, and you can't actively try a government without questioning its sovereignty. So I think it's a bit of a sticky situation where
you're just transferring
where not much can be
from
done.
one body to another body.
Yeah, I think in that case, not much can be done, because it would be slightly different. I guess maybe with something like terrorism, it's more maybe a strong enough regional force can combat something like terrorism. But I think even if you have the strongest regional force ever assembled, because of the sovereignty of the state and just the immunity that like a head of state carries, you can't really bring that person to justice until after they have left power. So I think it's like what happened with al-Bashir, where after he left power, that's when he was tried for these things. So I think let the state solve the issues domestically. If they manage to depose whoever is, doing these crimes, that's the only way they can be handled.
All right. Thank you so much for your time. At this time, we're going to interview the second person. Afternoon.
Hi, how are you?
Good, good. How are you doing?
Good.
So I'm just going to ask you two questions. All right. The first is, do you think it's too ambitious for African countries to be pulling out of the ICC?
Yes and no. Yes, mainly because, well, when we look at Africa already and the African Union, it's not so much a strong structure, even the legal system, for it to cater and combat issues regarding terrorism, war crimes, genocides by itself. I mean, most of these organs within the African Union already heavily rely on foreign intervention. So I mean, though the ICC has its faults, it would rather be better to remedy the ICC and then create an infrastructure that's well inclusive, or that removes that aspect of racism within the ICC, since it is a legal and justice system, before we go too ambitious. Yes, also, well, no, I think it wouldn't be bad if Africa left, because they also need to stand for themselves and look for an African solution to African problems. Therefore, creating and propelling a justice system, or a system that basically eradicates crime within an African manner, would be great as well. So those are my thoughts. It's a middleman type of situation.
All right. And the next question is, what's the way forward for African countries in dealing with human rights violations, war crimes, and their perpetrators, and terrorism?
Wow, that's a very tricky one, but I think still reliance on the international community, because we do face situations where the leaders could be the ones propelling the violations, the human rights violations, the war crimes, genocides, etc. So we need maybe mitigation, diplomacy as well within the continent as a system, before we just run to foreign aid, foreign intervention, and foreign assistance. So I think also just having a small body of executives that fairly represent democracy or peace and actually uphold human rights would be necessary to combat or to actually assess the situation within Africa.
All right. Thank you so much for your time.
Thank you.